Day, so I slotted you in. I had to finish with the appeals. The prosecution, please introduce your team.
I have Mr. Honda up here.
Ningo. Sarah Wairimu Kamodo, sorry. Do I need to recap the summary of the submissions? With your permission, can I just go straight to my analysis? Okay. Issue for determination. The issue for determination is whether there are compelling reasons to deny the accused bail. A preliminary issue arises from the defense submission that the court is being asked to revisit a decision by Lady Justice Stella Mutuku in Republic versus Sarah Wairimu Kamodo 2019, where the issue of bail was conclusively determined on 11th October 2019. It is strike law that a court cannot sit on an appeal over its own decision, and if proven, this would warrant dismissing the objection. The facts are undisputed. The accused was first arrested in 2019, pleaded on 3rd October 2019, and was discharged after a nolle prosequi in HCCR 60 of 2019. The matter later became inquest number E009 of 2023, which terminated on 2nd October 2024 after new evidence prompted a review by the DPP. The accused was later arrested and charged in this file. In the previous ruling, I discussed the nature and consequence of a nolle prosequi. I expressed myself as follows. My understanding of these provisions is that a nolle prosequi can either lead to an acquittal or discharge depending on the stage of a trial. Section 82 of the CPC is expressive that a discharge is not a bar to subsequent proceedings against an accused person on the same facts. The provision says subsequent proceedings for a reason. This means that the prosecution can institute fresh proceedings. There is no provision requiring the prosecution to reopen the same file. Further, once a nolle prosequi is entered, the file is closed. Additionally, the power to enter nolle prosequi is meant to give the prosecution a chance to put its house in order. If new evidence emerges, the prosecution can have a second bite. I am not convinced, and I have not been pointed to any law or jurisprudence requiring the prosecution to reopen the case previously closed. End of quote. Once the ODPP enters a nolle prosequi, it may reopen the case if new evidence emerges. Otherwise, the file is closed and effectively dead, relegated to the archives. This is particularly relevant here as the ODPP has initiated fresh proceedings. It provides, and I quote, an arrested person has the right to be released on bond or bail on reasonable conditions, pending charge or trial, unless there are compelling reasons not to be released, end of quote. The test for denial of bail is therefore the compelling reasons test. The High Court has defined the term compelling reasons in R versus Jackton, Mayende, and 3 others, 2012, to mean, and I quote, the phrase compelling reasons denote reasons that are forceful and convincing as to make the court feel very strongly, please switch off. Reasons that are forceful and convincing as to make the court feel very strongly that the accused should not be released on bond. Bail should not therefore be denied on flimsy grounds, but on real and cogent grounds that meet the high standards set by the Constitution. Flowing from the above, this court is also enjoined to take into consideration the Bail and Bond Policy Guidelines 2015. As much as the guidelines are not law, it is not in dispute that they have acquired the status of binding rules due to their wide practice by criminal courts. The compelling reasons are listed, are provided in the guidelines, and one is the nature of the charge, the seriousness of the punishment, the strength of the prosecution case, the character and antecedents of the accused, failure of the accused to honor bail terms previously granted, the likelihood that the accused will fail to attend court during trial, the likelihood of interfering with witnesses, the need to protect the victim of crime and the accused person. Also, the relationship between the accused and potential witnesses, etc. Now, the test of compelling consider the grounds of objection to bail advanced by the prosecution. First, the state argued that the accused is a flight risk, citing paragraph 16 of ASP Maxwell's affidavit, which claims her release could hinder investigations into other suspects. It is undisputed that the accused is a Kenyan, has remained in Kenya since her initial arrest, and actively participated in both the first trial and the subsequent inquest without missing court appearances while on bail. Notably, after the nolle prosequi in 2019, the accused had 6 years to flee, knowing very well that fresh charges could arise at any time, yet she did not. This therefore undermines the claim that she is a flight risk. The prosecution has failed to provide tangible evidence that the accused is likely to abscond. This aligns with established jurisprudence reinforcing that mere assertions without proof are insufficient to deny bail. I'll cite Lady Justice Mutende in Republic versus Abdullahi. She expressed the test to be the totality of the circumstances and further considering the serious nature of the offense and sentence. It is demonstrated that the accused is a flight risk and no amount of stringent bond terms or conditions would avert the chances of absconding trial. The holding in Republic versus Abdullahi above indicates that reasons advanced by the state must be strong, convincing, and forceful to warrant the denial of bail. It was therefore incumbent upon the prosecution in this case to convince this court that the temptation for the accused to flee in this case is so high that it amounts to a compelling reason. From the foregoing jurisprudence, the argument advanced by the prosecution that the accused is a flight risk is based on mere fear, apprehension, and speculation. Every case must be considered on its own peculiar circumstances, since every accused person has the right to dignity of the person. I have not been persuaded that the accused is a flight risk and have no hesitation in dismissing this ground. Secondly, the prosecution alleged the accused is likely to interfere with prosecution witnesses, having already attempted to do that. Witnesses are crucial to criminal trials, prompting legislative and institutional frameworks like the Witness Protection Act to safeguard them. Section 6(1) of the Act outlines measures to protect witnesses, ensuring the integrity of the criminal justice process. Without witnesses, cases collapse, hence making their protection paramount for both public interest and administration of justice. Witness interference undermines the criminal justice system, perverting trials into mockeries and prejudicing victims' rights. When bail objection cites witness interference, a court must carefully assess the objection, since protecting witnesses safeguards the trial integrity. I agree with Justice Lesit in Frederick Oleleliman and others 2016, where she emphasized that witness protection is essential to maintaining the fairness and credibility of the judicial process. She said, undermining the criminal justice system includes instances where there is a likelihood that witness may be interfered with or intimidated, the likelihood that the accused may interfere with the evidence or may endanger an individual or individuals or the public at large, the likelihood that the accused may commit other offenses. In these instances where such interferences may occur, the court has to determine whether the integrity of the criminal process and the evidence may be preserved by attaching stringent measures to the bond or bail term, or whether they may not be guaranteed, in which case the court may find that it is necessary to subject the accused to pretrial detention. The test on the interference of witnesses was laid out by Justice Corriff also in R versus Dwight Sagari, where the learned judge stated it must place material before the court which demonstrates actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and witnesses, and a close familial relationship between the accused and witnesses, among others. I also concur with the holding in Panju versus Republic 1973, East Africa, page 284, where the court, in dismissing the prosecutor's fear of interference with witnesses, stated that before anyone can say ASP Maxwell's affidavit has demonstrated that these witnesses were employees of both the accused and the deceased. The accused, in her affidavit and through her counsel, also uncontested that the witness report by affecting either the credibility of the witness in his or her testimony before the court or the ability of the witness to attend court. The tenderness of age or the mental acuity of the witness may be factors to be considered in the determination of the likelihood of interference. The nature of the testimony of the witnesses as eyewitness or circumstantial is also relevant. End of quote. It is established that the accused and the two witnesses were engaged in an employer-employee relationship characterized by a power imbalance inherent to superior-subordinate dynamics. The evidence on record indicates that attempts were made by the accused or her associates to intimidate the witnesses, thereby deterring them from giving testimony against the accused. The defense contends that 6 years have elapsed since the commission of the offense, hence diminishing the probability of witness interference. I do not agree with this thinking. Interference may manifest at various stages, including during investigations, throughout the trial, or subsequent to the filing of charges, and may involve actions by the accused, witnesses, or other parties. In Republic versus Robert Kipkorir Tonoi 2020 decision, this court previously held that witness interference undermines trial integrity regardless of timing. Thus, judicial precedence has time and again held the view that interference with witnesses amounts to interference with the administration of criminal justice and is a compelling reason under Article 49(1)H of the Constitution. In R versus Jackson Mayende Supra, Justice Gikonya stated, while dealing with the question of interference with witnesses, rendered himself, all that the law requires is that there is interference in the sense of influencing or compromising or inducing or terrifying or doing such other acts to a witness with the aim that the witness will not give evidence or will give particular evidence or in a particular manner. Interference with witnesses covers a wide range. It can be immediately on commission of the offense, during investigations, at the inception of criminal charge in court, or during the trial, and can be committed by any person, including the accused witnesses or other persons. The descriptors of this kind of acts which amount to interference with witnesses are varied and numerous, but it is the court which decides in the circumstances of each case if the interference is aimed at impeding or perverting the course of justice, and if it is so found, it is a justifiable reason to limit the right to liberty of the accused. End of quote. I do not agree with the defense counsel's argument that the passage of time does ipso facto mitigate against the threat to witnesses. The passage of time does not inherently reduce the risk of intimidation or interference. This trial, being in its early stage with no witness testimony yet presented, underscores the ongoing relevance of potential threats. It is a factual misrepresentation to assert that threats against witnesses are necessarily most imminent around the time of the commission of the offense. Threats can indeed occur at any point in the timeline of a case, prior to, during, or following the act, through the investigations, during the trial itself, and even post-trial. Given the unpredictable nature of when and from where threats might arise, courts maintain the authority to implement protective measures for witnesses at any stage of the proceedings to ensure their safety and the integrity of the judicial process. This capability reflects the judiciary's recognition of the continuous and evolving nature of witness vulnerability. From the analysis above, the likelihood to intimidate or interfere with witnesses has been proven with sufficient evidence. Moreover, this is a case of public interest where a life was lost in the most heinous manner. Article 24 of the Constitution appreciates that human rights can be limited. The provision sets out a limitation criteria that should be followed when limiting rights. The limitation is therefore a synonym for justifiable infringement. The infringement will not be unconstitutional if it takes place for a reason that is accepted as a justification for infringing rights in an open democratic society based on human dignity, equality, and freedom. The right to bail and the right to liberty can therefore be limited when circumstances so demand. The Supreme Court of India echoed this position in Masru versus State of Uttar 209, where the court held there is no denying that the liberty of an individual is precious and is to be zealously protected by the court. Nonetheless, such protection cannot be absolute in every situation. The valuable right of liberty of an individual and the interests of the society in general have to be balanced. The liberty of an accused person should depend upon the exigencies of the case, if possible, that in a given situation, the collective interests of the community may outweigh the right of personal liberty of the individual. This case requires balancing the accused's right to liberty and bail against the administration of justice. It is my considered view, therefore, that the principles of justice and public interest outweigh the accused's right to liberty at this stage. The court must safeguard the trial's integrity by protecting witnesses and preventing potential interference. In the circumstances, I decline the accused's application for bail. The accused shall remain in custody until after the two witnesses have testified. The accused is at liberty to revisit the issue of bail at that point. That is the ruling of the court. Okay, I'll take your names again. Mr. Monda, Ms. Gishuhi. Again, Mr. Maloba.
Mr. Mingo.
Mingo. Ms. Obuya. Mr. Amalemba.